Well, hello, everyone, and welcome to this special edition of HOA Today. I'm Mark Foster on the HOA Leadership Network. I'm joined today by attorney and partner Finn Jacobsen. He's with the law firm Smith, Jaden, and Johnson, SJJ Law, one of our great sponsors here in the metro area. Finn, thanks for joining us in a pinch today.
No problem. Thanks for having me, Mark. I really appreciate it.
So, Finn, our subject is HOA reform legislation. It's on everybody's minds. It's been a busy end of April and a probably frenetic start to May in the state legislature with lots of HOA discussion and some things that will impact HOA board leaders, it looks like. We're going to talk about Senate File 1750. It passed the House just last week, and then the Senate this week on May the 6th, I believe. And it passed by a wide margin, and frankly, kind of surprised me a bit by how wide of a margin. And it looks like it's destined to become law with a signature from the governor probably any day. So my first question, Finn, is as an attorney and as someone who's been watching this for the better part of, a year and a half, certainly two consecutive sessions where this thing has been bubbling in various forms. Do you feel like with all the changes that were made, all the amendments that were made, all the discussions, all the last minute stuff happening in committee, is this bill really ready for prime time, in your opinion?
Well, whether we like it or not, it's in prime time now. But to answer your question, no, I don't think so. Like you said, this bill has been percolating around the legislature for about 2 years now. And it's not like every time this bill has been read in another committee, they've made some fine-tuned tweaks to it. These have had this bill has had what are called 13 delete everything amendments, DE 13. So that means, okay, we're going to do a new version of this. Well, it's not really an amendment if you're just wiping everything off the slate and starting from scratch. So the bill that passed the House last week and the Senate yesterday looks completely different from even the version that passed the Senate last year on May 6th. So every iteration of this bill has been fundamentally different, not fundamentally different, but has been substantially different than the previous iteration. So all of the various committees that should be doing the work of, questioning what's in there, questioning how it will work in practice, hasn't been done because things get added at the last minute or a new delete all amendment. And this was there's no better example of this than what happened on the Senate floor on May 6th. There were a handful, I think 5 amendments that were offered at that Senate hearing, I believe 2 of which were adopted. But there were so many changes to it that there were several people who said, we don't know what's going in this. This hasn't gone through the process the right way. Senator Latz in the Senate actually stood up and sort of railed against the bill and the fact that it didn't go through the committees the way it should have, and pushed to have it go to conference committee. So when all of these changes are happening and they're not getting this sort of thorough look that they should, I don't think this bill is ready for prime time. Interestingly, and I'm sure there's a political reason why, but Senator Latz, despite sort of spending the better part of an hour railing against the bill, ultimately voted in favor of it. And as you pointed out, Mark, a lot of the senators and legislators did. I mean, it passed pretty overwhelmingly in both houses.
Yeah, wide margin. I think it surprised everybody. Now, the last couple of weeks, we've all been noticing it's been labeled the HOA Bill of Rights. Some are saying that that's just a marketing label for it to, allow for a much quicker passage. Maybe that's true. Others see it as truly this revolutionary set of requirements that will positively change the industry. What say you? What's your opinion?
I mean, I don't think I think to your point of it being a marketing piece is spot on. I think Representative Bonner, the self-proclaimed queen of HOAs, as she said in her, victory lap in the House floor the other day, I think she wanted to call it that because it's a good tagline for a re-election campaign. It sort of cements herself. She's sort of cemented herself as the go-to person in the HOA space. But calling it a homeowner bill of rights, I think is a misnomer. I don't think it does anything to protect homeowners. In fact, I think the ultimate result of this will be the opposite. I think it will hurt homeowners. One thing that Mark, and your members of the leadership network know, and something I talk about regularly, is it's not like the HOA is this big, scary, evil third party entity. It's you and your neighbors. And so when you are giving rights to the neighbors, well, let's be clear who these rights are being given to. It's being given to all of your neighbors, but you're also the HOA. And what I'll tell you, based on what we saw in the working group and the, stories you see Representative Bonner or other people give when they're talking about this, these are people with access to grind. These are the exception, the one-off situation. Oftentimes homeowners who didn't have the right insurance or shouldn't live in an HOA because they don't want someone to tell them, that they have to have this type of siding or this type of roofing. And so really, when you're protecting those homeowners, you're protecting the bad actors, which is going to increase costs. And all that's going to do is push that cost back onto the compliant homeowners. I mean, I've spent the better part of the last 2 days looking at what this bill, now that it's in its final form, is going to do. And almost every single association in Minnesota is going to be required to draft some new policies, have some new procedures in place. And all that means is, at worst or at best, they're going to pay an attorney, someone like me, to do that, which is going to increase costs for all the homeowners. Or at worst, they're not going to comply. They're going to get sued. And then they're going to be out even more money fighting about this in the courts. So yes, they call it the Homeowner Bill of Rights. I think it's a marketing piece. And I think, frankly, it might better be called something like the bad Homeowner Bill of Rights, right? It's just protecting those bad apples.
Well, and we'll talk a little bit about some of the components of this bill, both positive, because there are some, and some of the
Absolutely.
negative ones here in a minute. And I do want to mention at the bottom of our screen, there's a QR code that our viewers can scan to take them to an event registration page for a webinar that we're going to be hosting to get into the detail on this later this month in May. So we'll get to that a little bit more at the very end, but just wanted to make sure everybody understood that QR code is available. So, Finn, before we dive into some of the provisions of the bill, there seemed to be some confusion, even on the Senate floor, when there was a discussion around when this bill was going to become law. So obviously, next step is that the governor would sign it. So presuming the governor signs it, is it an August start or is it a January start?
There's one provision that will be effective immediately, and that's the change in the definitions section. That goes into effect as soon as Walls' signature is on the bill. With the exception of that, and that's not really substantive, everything else goes into effect January 1st of 2027.
So we've got some time in order for us to get ready, and one of those things will be to, certainly stay in tune with the network and some of the content we'll be providing. And we'll, as I mentioned, we'll talk about our upcoming webinar here in just a moment. There are some positive things in this bill, Fan. I think you and I both agree that from a best practice standpoint, there's some things that many boards are already doing and probably won't affect them in the least. Are there just a couple that you want to bring to the table here to discuss the positive parts of this bill?
Yeah, there's absolutely a lot of good stuff in here. There's no doubt about that. I want to make sure everyone understands that. The problem is there's a lot of bad things too. The good things, though, to sort of harp on those, there's a lot of new language in resale disclosures and annual packets about loss assessment and resale disclosures. As you know, and I think a lot of your listeners probably know, almost every one of the stories you see in the news is the same fact pattern, as lawyers like to say. It's an insurance claim with a large deductible and homeowners who don't have the right insurance. We can't fix that. We can't force them to buy insurance, at least yet. But what this bill, one of the things it does is it has very, very explicit language in all caps explaining you may owe a loss assessment. The deductible is X. You still owe that even if you don't have insurance. That sort of additional disclosure, while I will hope it changes and gets people to actually buy the insurance, it probably won't, but it's going to make the fight easier when an association has, the angry homeowner who says, I didn't have the right insurance. You can't make me do this. Well, here's the document that we gave to you that says that 18 times, and we've given it to you 7 different times because the law now allows it. It also, as you said, Mark, enshrines a lot of things that I would consider best practice. Things like having a collection policy, making sure you outline kind of at what steps the association takes or at what stages the association takes what steps with collections. Having that be clearly articulated, that the board can follow, takes the guessing games, takes any sort of disparate impact. I want to be nice to my neighbor because I like him. Nope, we got to treat everybody the same. I think that's really good.
Yeah, exactly. And I do think you and I both agree that for the most part, a lot of well-run boards are probably doing many of those things today, so there won't be much of an impact. But there's a couple of things in here that are problematic. One that I'll just bring up and ask for your opinion on is the fact that now residents during a board meeting can opine on really any agenda item at any time, which is contrary to what is a normal sort of Robert's Rules of Order type of parliamentary approach that goes on in most board meetings. That gives me a little bit of stomach acid. That's one thing that's a bit problematic. Would you agree on that? And maybe what are a few other things that give you some pause?
Well, one, I'm going to start why I hate Robert's Rules of Order. I don't ever recommend anyone follow it. It's too your board of directors for your HOA is not a 500-person parliament. You don't need these very sort of fancy things and mechanisms. But with respect to people speaking, I mean, a lot of associations that I work with already have that. They usually call it homeowner forum. I think that's a good thing. The way I read the law is that you have to give people the opportunity to talk. You can limit how much time they can talk. So the reality is, if I've got my board meeting, maybe I just say we call it to order at 6 p.m. For the first half an hour, because the agenda's already been provided to the owners. We let everybody talk. We give them 2 minutes each. The law does allow you to put a time limit on that. It allows you to make it a violation to sort of talk over that. It does require or recommend that homeowners give a heads up to the board, although it doesn't require it. So I think with the help of probably management companies, boards can set up procedures where they do that at the front end. You've talked about everything, and now you put that part of the meeting to bed, and now the board goes on with its business. So I do think there is some advantage to having people be heard with respect to board meetings and going and having the opportunity to talk to their neighbors who happen to run the community and say, hey, there's some issue with my fence and I'm not getting any responses. Can you guys help me with my fence?
Yeah, I think what you're pointing out is that there's some interpretation to this bill. I think that from what we hear on the network side, a lot of people, a lot of boards do allow for some, homeowner forum, and that is a wonderful thing. It's a great thing, and it should be encouraged. I think that it's being interpreted by some board members that it can be at any time on any subject, throughout the agenda, which I think some people are saying, boy, that's going to make my 2-hour board meeting 6 hours.
Oh, and to be clear, I think that in one of the delete all amendments, that is what it said. I think the current version just says that there has to be the opportunity before an agenda item is voted on.
Good.
So if you just assume we're going to do all the homeowner forum at the front end and then vote on all the agenda items afterwards, I think you'll probably be fine.
Okay.
There are a few other things in there that I think are problematic. That one of the big ones, and there's a whole section in here about how collections will work. and how you're going to have to do things with respect to collections when this law goes into effect. The one that kind of rubs me the wrong way is the cap on late fees and interest. So the cap on late fees, the interest cap is 8%, which makes some sense. That's the statutory interest cap for most other things in Minnesota. But the late fee is $20 or 5% of how much is owed. That may sound reasonable, but what if you live in an association where it's a $2,000 a month? And I mean, that's a lot, but there are associations that are that much assessment. Or even if it's just $300, which is probably somewhere in the ballpark of average. Let's say I'm a little bit short on my cash flow the next few months. So I just need that extra $300. I don't pay my association. Well, $20 for me to of a late fee to basically be floated that $300, I'm getting a very, very inexpensive loan from my HOA. And if 100 owners do that, that's a cash flow issue for the community. So capping that artificially the way the legislature did could create some cash flow issues, especially if you have communities and homeowners who want to use that as an excuse to say, hey, you can't do much to me for the next X amount of time. I'm going to use that and wait till I, get my tax refund or something like that. Because there's also a provision in here, and this one I sort of agree with, not sort of, I do agree with. You can't start foreclosure until someone's 3 months in arrears. I don't think anyone should start at the foreclosure process if you're, 1 month behind on assessments. So that makes some sense. I would have preferred to see some exceptions built in if, the person is dead or something along those lines, those weird situations that frankly we do run into with some amount of regularity, but this bill is far from perfect.
Well, then it sounds like the three bid rule where you need to get three bids on projects that are 50,000 plus. It seemed to me that they added some language to clarify that in emergency situations, that wasn't necessarily the case anymore. Is that correct?
Yeah. So that language, I believe, has about 9 exceptions to it. So one of them is, as you said, the emergency situation. So if you've got a fire raging and you need to go put it out, or if you've got water that just dumped into a unit and there's just standing puddles of water and you need, someone like ServPro or Paul Davis to come in and dry it out. You don't need to go out and get 3 bids. You can just do that. And that's good. The one part of the 3 bid that does give me a little pause, because I do genuinely believe that 3 bids makes a lot of sense when you're spending that kind of money. There is a provision, and it's a bit unclear as to what you have to keep as a document for the association when you get those 3 bids. So let's say, Mark, your association goes out and they want to get $70,000 worth of work done. They get a contract or they get a bid from Finn Construction, from Mark Construction, and from Lynn Construction, right? There's some provisions in this bill that say then all of those documents have to be kept by the association as a corporate record for 6 years. And not just the bid that won, right? If Finn gets the work and Mark and Lynn don't, you still have to keep the Mark and Lynn documents as a corporate record for 6 years. And as you and I both know, yeah, in a perfect world, of course, they would keep all those records perfectly, but they're not going to always. There are going to be situations where those records don't make it from management company A to management company B. Not to mention, in my mind, a bid that was not signed and passed upon. I'm not sure the benefit of holding on to that for 6 years, other than, frankly, to give a homeowner 6 months, 8 months, a year down the road some fodder to come after the board and say, well, why did you go with Finn Construction instead of Mark Construction? Mark was cheaper. You clearly are, and you're just going to have, not often, but there will be situations where you have homeowners use this and weaponize this to go fight their HOAs.
Well, there's a lot to unpack with this bill, and we'll be doing that in this upcoming webinar. Before we start to close out here, Finn, there was another bill, I believe it was a Senate file 3622, which also sailed through the House and Senate, a largely technical bill that seemed to be championed by the Minnesota Bar Association and is largely considered to be a cleanup bill. Is that something that should keep us up at night as board leaders?
Not even a little. That one was, like you said, Mark, pretty technical. It was cleaning up weird cross references, things that, only attorneys who deal in this every day would have realized is a problem. Frankly, I would expect that sometime in the next 4 to 5 years, we'll have a similar bill cleaning up 1750 because there's a lot of issues with it.
Well, we have several months before this bill goes into effect in January of 2027, assuming the governor will sign it. All signs seem that he will indeed do so. In your opinion, Finn, what should HOA board leaders do, if anything, right now?
I mean, right now, the name of the game is education. I mean, obviously, Mark, you and your organization do a great job with that. We've got our webinar coming up where you and I will discuss this in more detail. But learning, one, if it applies to you, if you're an MCIO association, understanding what the new requirements are. I mean, we put a blog post up just today with a high-level summary. I'm sure many other practitioners in the area will do similar things, but learning about what you'll need to do so you're ready come January 1 is the name of the game at this point.
And let's talk a little bit about that webinar. So we have a 4:30 May 28th online webinar that you'll see the QR code at the bottom of our screen. You can scan that QR code and it will take you to an Eventbrite registration. You need to get on that registration page so that a link can be sent to you about 48 hours prior to the event. We're co-hosting this with HOA Leadership Network and SJJ Law. So it'll be with Finn Jacobsen and also your partner, Aaron Brooksby. So give us a little bit of a preview. What are some things that participants can expect to see during that webinar, Finn?
Yeah, we're going to probably get down into the details of what the bill does. There's a lot of stuff it'll deal with fines and violations. We'll talk about what that means, how you should be approaching your fines, your violations, your collections. There's some, nitty-gritty governance stuff that's going to have to change in terms of, hey, you need to make sure this is in your annual packet. So we'll talk about that. We'll probably go through some of the stuff that probably doesn't apply to most associations quickly. There's some update to the termination language. There's some stuff about what cities can or can't do with respect to HOAs. But for that webinar, we'll probably get down into the nitty-gritty of the stuff that will affect the board leaders and the homeowner leaders and what they can expect to see.
Sure. And space is limited, even though it is an online webinar. So be sure you register soon. It is filling up. We've got a lot of traction on this event already. And it sort of points to the fact that this is going to be on people's minds for many months. We'll continue to discuss it in our chapter meetings. I know that you guys have always been a great resource. I'm sure you'll be having some materials that you'll be sharing that we would love to also distribute. And I guess just stay tuned, right? More to come.
Sounds great. More to come.
All right. Well, Finn Jacobsen, SJJ Law, you're always a terrific resource for us, a great sponsor. Thanks for joining today.
Thanks, Mark.
If you're not a member of our network, please go to our website at www.hoalnet.com and join as an HOA leader. It's free. For HOA Today, I'm Mark Foster, and this is the HOA Leadership Network.